Good morning, Bhumika ma'am.
Shubinda,
Yes, sir.
two more judicial officers, I think, likely to join.
Okay, sir.
Just East and Lawrence West. We are requesting to wait for a few minutes.
Okay, sir. Okay, sir.
Can I just ask one question?
Sir, please.
Am I audible? Am I audible to everyone?
Yes, sir.
Because your voice is cracking.
Yes, ma'am. Awesome. It's not clear from here.
Shudinla,
Yes, sir.
because they have requested, they have technical issues
Okay,
and
sir.
requested to start the session. Yes, please proceed.
Good morning, everyone. With the permission of the Learned Director, I, on behalf of Sikkim Judicial Academy, would like to begin today's program. To conduct the session, we have Mr. Kamal Wongchuk Bhutia, Learned Registrar General, High Court of Sikkim, as the resource person. I also take this opportunity to warmly welcome all the learned judicial officers for today's program. May I now request Learned Director to kindly give the welcome address.
Good morning, sir.
Yes, Shudinla. Thank you so much. It is my pleasure and privilege to have the benign presence of learned resource persons of today's program, who is none other than the Learned Registrar General of Honorable High Court of Sikkim, former Central Project Coordinator and the Master Trainer of E-Committee Supreme Court of India. In this occasion, I, on behalf of Sikkim Judicial Academy, would like to extend warm welcome to Learned Resource Person for having joined with all of us in this platform to deliberate on various model of E-Court Mission project prepared by E-Committee of Honorable Supreme Court of India to implement across the justice delivery system of our country and other rules pertaining to information technology being invoked before Honorable High Court and Supreme Court of our state. I equally would like to welcome all learned judicial officers who have joined this platform from all districts and subordinate court of our state. I welcome you all. And the learned resource person need no further introduction. Without wasting further time, I would like to request the learned resource person to kindly begin the deliberation on the session of today's topic. Thank you.
Thank you, sir, for your kind words.
Yes.
Good morning to one and all. First of all, the director of the academy, thank you for choosing me as one of your resource person. It is an honor to be a part of the academy and to be amongst my learned senior members of the fraternity, as well as the other colleagues and brothers and sisters. There are 3 topics that has been assigned to me by the director of the academy for deliberation today. I'm sure that most of you have already undergone a training of this kind in some way or the other, and in some topics or the other. And I'm also sure that all the participants must have gone through the VC rules as well as the digitization of record rules, which has been in circulation and which has been in implementation for a long time. To begin my topic, I'd like to give a short introduction about the E-Committee of the Supreme Courts, because session 1, the topic is Introduction to the E-Committee, E-Courts Project, the ongoing initiatives under the E-Courts Project with reference to the High Court of Sikkim and the subordinate courts of Sikkim. So with these words, I'd like to begin. The E-Committee of the Supreme Court of India and the E-Courts Project is an initiative to implement the Information and Communication Technology initiative in the judicial system of our country, Sikkim and the courts in Sikkim being no exception. The E-Courts Project was conceptualized in the year 2004 and began functioning from 2007. In 2007 and up to perhaps 2009, it was in a formative stage where many of us who were in service at that time will know that as an initiative, the first thing that was done was that all the judges in the district judiciary were provided with laptop computers. Along with that, the operating system that was provided was Linux, one of the version of Linux, that is Red Hat.
I wanted everybody else to be.
My personal experience was that Red Hat did not, though it had a lot of advantages, but it had quite a number of disadvantages as well. We were not able to access many of the media files properly in Red Hat, and there were many other complications. As I said, it was in a very formative stage, and out of experience, the E-Committee Supreme Court of India thereafter decided to change the operating system from Red Hat to Ubuntu. Now the latest is, I think, 22.4 is also already, many of us must have been using 22.4, but 20.4 I believe is quite stable, and that is the version that I am also using. The E-Courts project is a pan-India project, and it is monitored and funded by the Department of Justice, Government of India, under the Ministry of Law and Justice. Now, it has certain objectives, and the core principle of E-Courts project is number one, that technology must be harnessed to empower and enable. What it means is that technology should not merely be about automation of conventional practices and processes, but must be a vehicle of transformation, a force which empowers and enables all citizens, which ensures access to justice for all, and in turn, it creates an efficient as well as a responsive judicial system. Now, what are the objectives of the E-Committee of the Supreme Court of India? The E-Committee is guided by these following objectives. It intends to interlink all the courts across the country through one platform. The other objective is to enable information and communication technology, or ICT in short, in the Indian judicial system. It enables the court to enhance judicial productivity both qualitatively as well as quantitatively, and to make the justice delivery system accessible, cost-effective, transparent, and accountable. As we all know that there were certain phases of the e-courts project. Phase 1, which was there earlier, and then there was that phase 2. And in phase 2, the real objective of the phase 2 was to plan and schedule cases for lawyers, case management for judicial officers, and also caseload management. There are, I think, certain participants whose microphone is on. I'd like to request that please keep your microphones off, because otherwise there'll be, I think, a lot of echo and cross communication. Okay, I'll continue further. Now, after giving you a brief introduction about the E-Committee of the Supreme Court of India, let me inform the learned participants as to what the High Court of Sikkim has done and what are the initiatives that we have done. From the High Court of Sikkim is not only per se the High Court here, but also includes all the district courts and the courts in the subdivisions. Now, the number one initiative that we have implemented is the CIS, or the Case Information System. Now, Case Information System is a software. You may say it's a giant software where the data of the courts across the country is available, the district judiciary as well as the High Court. Now, there are versions of CIS respectively for the High Court and for the district courts. Now, for the High Court, there are also in CIS, there are various versions. Now, the version that we use in the High Court is 1.0, which is the initial version. And you all may be aware of the fact that in the district judiciary, we have now migrated to 3.2, the latest version of the CIS. Now, it was created, the CIS was created under the guidance of the E-Committee, Supreme Court of India, through a software team of the NIC, Pune. And the whole idea is that the litigant should be able to view the daily case status, the orders that are uploaded by the courts on an everyday basis, and the progress of the case on a day-to-day basis. This is one initiative that the High Court of Sikkim has already implemented. The second is the provisions of laptop and printers to all the judicial officers. I'm sure most of you must be connecting from the laptops and printers, from the laptops that has been provided under this project. And even I am connected to all of you through the laptop that has been provided by the High Court under this project. Give me one. The other initiative is the procurement and installation of LAN, the local area network, which has been completed in all the 4 districts. Now we have 6 districts, but in all the 4 districts we have already completed, and also in one of the Soreng subdivision complex. Apart from LAN installation, we have also installed in all the districts and all the court complexes the MPLS connectivity that was initially planned by the Department of Justice, and now it has been taken over by the High Court and the state government for implementation. Apart from this, the other initiative is the digital signature that you all know, the digital signature certificate, which has been provided to all judicial officers in order to enable them to sign on their judgments, their the orders on a day-to-day basis on an electronic form whenever required, and to upload it in the CIS, which ultimately goes to the National Judicial Data Grid. The other initiative is the video conferencing facility, which we are presently using. Now, to inform you and to remind you all, it was on the 20th of September 2017 that Sikkim became the first state in the country to achieve 100% implementation of video conferencing facility between the district courts and the jails. There was a function on the 20th of September 2017 presided over by the then chairman of the E-Committee, Supreme Court of India, Honorable Mr. Justice Madan B. Lokur, and which was attended by the Honorable Chief Justice of this High Court, the Honorable Judges, and the other dignitaries. Apart from this, we have also implemented solar power project in all the courts across the state. The first court being the District and Sessions Court at Gangtok, where the installation of the solar power project was completed. And by now, we have completed installation of solar power project in almost all the subdivisions. Apart from that, in all the district courts, it is already in use, and I'm sure you must be enjoying and you must be understanding the benefit of solar power projects, especially in the far-flung subdivisions such as Chungthang, maybe Yangang, and the other subdivision courts. Now, e-filing and e-payment is also one of the software or one of the important. It is an important aspect of the E-Committee's project, by which the filing of the cases from physical filing we have now migrated, or we have upgraded to e-filing, and also for payment of court fees and challans. Apart from physical payment, we have also introduced the system of e-payment, which we have also integrated in our own website of the High Court, that is hcs.gov.in. Any person or anybody, any litigant, any lawyer who desires to file their cases now can file it from the comfort of their homes, their offices, just by clicking and going through the website of the High Court, and by filling certain requirements. And one thing about e-filing portal is that unlike regular filing in a physical form, what has been provided to the lawyers or the litigants is that you can also save whatever work that you have done, keep it pending in your e-filing account, and later when you're ready with all your documents, all the other papers, and you think that it is absolutely correct, then you can go ahead and do your filing. Similarly, the e-payment portal has also been integrated with e-filing so that payment of court fees is made easy. And it was launched for all the courts of Sikkim on the 3rd of August 2020 during perhaps the peak of the pandemic. Apart from this, we have E-Seva Kendras, which has been established in all the courts in the state. The district and session judges of all the districts, as well as the civil judges manning the subdivisional courts, will know that E-Seva Kendra has been a milestone to provide an access to the common litigants as well as the lawyers who do not have the facility of internet or the other facilities such as computers, scanners, so that they can also take the advantages of e-filing, e-payment, and other modes provided by the e-committee. Justice Clock is another installation which was done in the High Court, and it is functional since February 2020. I'm sure that by now Justice Clock may have been installed in District Court Gantok as well as Namchi, because we have already made the procurement, and we have already got the fund for payment of Justice Clock for these two districts. And as I was talking to the CPC just yesterday, they have also made a provision for installation of Justice Clock after getting the funds from the E-Committee for the other two districts of Mangam and Gyaltsing, respectively. Now, the advantages of Justice Clock is that any messages that the courts intend to display it in the court premises can be displayed in the Justice Clock. Now, as you all know that on the 12th of November, you have the National Lok Adalat, and here in the High Court, what we've been doing is we've been displaying the messages of the Sikkim Legal Services Authority, informing the litigants and anybody who happen to pass through the premises of the High Court the information that 12th of November is the National Lok Adalat, and perhaps 5th of this month or today may be the last date for filing of the cases for the National Lok Adalat. Now, Justice Clock has also been important insofar as informing the litigants who happen to be outside or in the premises about the cases that is in progress, which the other courts in the districts can also utilize. These are some of the initiatives that the High Court of Sikkim has taken. And as I have spoken for almost 10 minutes, and it's almost pin drop silent here, I'd like to ask my learned members, the participants, and my brothers and sisters, that if you have any questions on these, or if there is any interaction that we can do, otherwise it is becoming very, very quiet here, and it seems that I'm the only one speaking to myself. So may I ask anybody if there is anything that you'd like to ask on any of these initiatives, so that we could have a little bit of interaction as well.
Yes.
May I ask you about this Justice Clock some more?
Yes, ma'am.
Can I ask?
Yes, ma'am. Yes, ma'am.
Yeah. So, is it provided only for
As I said, Justice Clock, the budget for Justice Clock, we received the budget from the E-Committee. Initially, it was only for the district, only for the High Court. So we've installed it from February 2020. We've been using it. Now the fund is already sanctioned, and I think the procurement has also been made for District Court Gantok and District Court Namchi. In the first phase, it will be installed very soon in these two district courts. And apart from that, just yesterday, there was a meeting of the E-Committee where our CPC attended, along with the CPCs from across the country. And what I've come to understand is that they have also asked for budget for the District Court Mangam and for Gyaltsing respectively. And once they get the budget, they will need the procurement for these two districts as well.
Why is being discriminated?
East and Gangtok and Namchi are the first courts, district courts.
Okay, I didn't know again.
Okay. These are the first district courts that procurement has already been made and it will be installed very soon. Keeping in mind the number of cases and the litigation that we have in Gangtok, the first priority was given to Gangtok, ma'am. Yes.
Thank you.
Any other questions from any other participants, please? I'd like to request the director not to ask questions because if he starts, he will not stop. All right, to go ahead, there are the initiatives that we have taken, apart from these many that I have already discussed, is that it's about the National Judicial Data Grid, which we all know. It is a flagship project implemented under the aegis of the e-Courts project and has been recognized as an innovative project. And you must have known that the NGDG, this particular project, or the particular software has received accolades across the country, and they have received a lot of prizes in a national level so far as ICT is concerned. I think last year also they received prizes for ease of doing business, which is an initiative of the Government of India. Now this portal is a repository of data about pending, about disposed of cases, not only about the districts and talukas, but also of all the high courts of the country. Now, it has been developed in a concept of Elasticsearch technology, which enables efficient case management and monitoring, leading to effective disposal of the cases. Now, data are uploaded and collated in this portal and can be accessed and analyzed category-wise, year-wise, date-wise, month-wise disposal of cases across institutions, across original appellate execution stage of litigation, and reasons for delay can also be seen and analyzed and accessed in NGDG. The other initiative is the ICJS, which is Interoperable Criminal Justice System. Now, it is a policy of the E-Committee that there should be a link between all the criminal justice system, across the country, be it the court, the police stations, the investigating wings, the forensic science laboratories, the juvenile justice system, could be the prisons, and other wings which are a part of the criminal justice system of this country. With this initiative, the E-Committee has provided a platform where metadata of FIR and charge sheet can be accessed by the subordinate courts as well as the high courts. Documents like FIR, case diary, charge sheet, these are uploaded by the police in PDF format for utilization of the courts. And so far as the courts are concerned, on the CIS portal itself, once these documents are uploaded by the investigating wing, which they have their own platform, which is known as CCTNS. And once they upload it in the ICJS platform, the courts can access it from their ICJS portal. Once they put their credentials, they can access and get the data of these police stations, the FIR charge sheet, and after validation, after authentication, the officers in the court manning the ICJS or the CIS can either confirm, and thereafter this FIR is consumed in the CIS. once consumed in the CIS, you all will know that in charge sheet there are a number of witnesses. At times, in a case like, let's say 420 or sometimes even PC Act cases, there will be a number of witnesses. Now, one of the advantages, there are several, but just one advantage that I'd like to inform you all is that the names in the charge sheet, the list of witnesses which are already there, once this data has been entered in the ICGS portal and consumed in the CIS, and you don't need to enter these names again. There could be 200, there could be 500, there could be 50 number of names. There are other details, and these need not be repeated again, and this can be replicated and be reused in any other platform of the e-committee that is connected with ICGS. Now, apart from this ICGS, the other initiative that the High Court of Sikkim has taken and implemented in all the districts is service of summons and processes, which is known as NSTEP. NSTEP is a mobile application which is accessed through a mobile phone. You must all remember that we had procured mobile phones for all the court officers, all the process servers, based on the number of requirements that we received from the districts. Procurement was made, NSTEP mobile application was installed, and it has been given to all the process servers across the state, in all the districts. Now, as we all know, why has NSTEP stepped in, let's say? NSTEP came in because of the fact that the traditional method of going to a particular place and running the summons took a long time. And also, at times there were a lot of people involved who didn't want the processes to be served or the summons to be served on time, which ultimately delayed the trial, causing again derailment of the plan that all the high courts and all the district courts makes for speedy disposal of matters or cases. Now, NSTEP has a web application, it has a mobile application, and it has a portal. Now, the administrator in the court can see once the bailiff or the process server goes to a particular place, serves the summons, gets the summons served. What they have to do is they just need to press a button, or even they have their pen where they can sign it on the mobile phone itself, where they have the touch screen. And once it is served, and once they confirm it, the administrator in the court immediately receives the information that it has been served, and there will be no causes of delay in service of summons. So these are some of the initiatives that the High Court has taken under the e-courts project for this High Court as well as all the subordinate courts of the country and the state. So I think I've come to an end of my topic number 1. If there is any question, please raise. Otherwise, I will go to the next topic.
So I have something.
Yes, ma'am.
So I think there's going to be.
Sorry, yes, I missed this. Yes.
So, sir, my question is with respect to coverage. Yes, sir. And like many times we face difficulties in accessing our official email ID, because I think you have to first log into coverage, then get an OTP, and then get into email ID. So, I just wanted to know whether this difficulty is just like maybe just unique to my own mobile settings, or is this a problem everywhere? And what should we do about it, sir?
Jana, that's a good question. Even I was facing this problem for quite some time. And what I realized is that coverage is one one security system where unauthorized access, in order to have unauthorized access, I mean, in order to stop this unauthorized access, Kavach used in the official email ID. Now, this is not under the e-committee or e-courts project, but this is an application of the National NIC. This is the software developed by the NIC. So in this, I will not be able to do much, but I will tell you one thing. Once you get your what you call the Kavach security done in your mobile, you can use the help of perhaps if there is any master trainer in the court. Now we have the technical man. Get your installation done properly. There is no problem at all. For example, this is my mobile, and here I have, as I can show you, email. I have aij.gov, and I also have NIC. So I can access all my email from my mobile phone itself. Now once I give that the Kavach a proper, I mean, if I put it properly, there is no problem, and I can even access it in my laptop. For laptop, of course, you will get what you are supposed to get is a validation. Now, you have your Kavach app, which you need to download, which is something like this, which is at the side of my screen. You download this Kavach, and then you'll be able to access your email, official email, or NIC, or GOV, or even AIJ. Honestly, I don't think there will be any problem. All right, man. Any other questions?
Thank you, sir.
I have a question, Arji.
Yes,
When
ma'am.
we downloaded the Kavach app on our cell phones, like in my case, I registered my email that is registered in the app is of the West District. Now, subsequently, can we change the details in the app?
Yes, of course. Madam, if I may seek a little clarification, and if I can understand, I think Madam is talking about Justice app.
No, Kavach.
Kavach, we do not need.
Because the
Kavach
email
can
that
be.
is registered over there, it is of the court in West. In
No,
my app.
no, it is universal. The one which Madam has downloaded, or you have kept it in your let's say the desktop computer of your member in Gyalsing, that has to be deleted.
Okay.
That has to be deleted because and when you are here, you can install Kavach app on your mobile and also in your laptop as well as the desktop. Kavach this email can be accessed across the country, not only from one district to another. This has no barrier at all, madam.
No,
If you are,
that is not my question. My question was, what about the details entered there? Can I change at the time of registration? No, that won't be a problem.
yes, sir.
It can remain as it is.
Of course, it can change. But once you have done it,
Transferred, because our details will change accordingly. No.
like for Kavach, madam, we don't need the details of the court. But for Justice app, I think we require, once we are transferred from one place to another, that we require we need to revise these.
So just for the sake
Because
of
when I open my app in the mobile, the registered ID shows as the Gyalsing District Court. That email shows. No, so that is why.
All right. I think what they must have done is, instead of getting your email ID, they must have put the email ID of the district.
So that is what I was asking. Can I?
Yes.
Is it all right
Yes.
to
Yes,
delete
madam,
this and
you can delete it. Yes. And yes, that can be deleted, and Madam's own personal email ID can be entered there. Because this personal, once we enter a personal email ID, it will remain with us. We do not need to again change this from one district to another.
Okay, thank you.
I hope, Madam, I could. Yes. All right.
So actually, just for the sake of discussion, I was following up on the Justice app after I was transferred to Gazing, and within a week I noticed that our new posting and our new designations, and then like the matters in the court was all updated in the Justice app. Within a week, I saw that the changes were done.
Correct. There are these administrators who are given access. We have our court master in our NJDG itself. The High Court has the administrator. So from here we can access and we can change the court master, the judicial officer's details, everything. So once you are transferred from one district to another, we can do that. And we have also given access, so far as the NJDG of the districts are concerned, to the district administrators. Right? All right. I will go ahead, keeping in mind that many of us, the honorable judges, may have a number of cases today listed also. And now we go to another topic, which is, I think, very, very important so far as the present situation is concerned. Now, pandemic has been one incident where people all over the world, not only the courts, people from all sphere of life, they were forced to use or take advantages of ICT. And one of the facility that was widely used is video conferencing, like we are doing it right now. So video conferencing is very easy. I mean, you can take a conference, you can record evidence, you can talk over, or you can discuss meeting anywhere, anytime, with a single click of a button. Now, during the pandemic, the courts had no other option but to either close down or function to one or the other mode. And the only mode that was feasible to everybody was to work contactless, but through video conferencing. Now, video conferencing is not a new concept. Video conferencing was there for a long time. Now, the only thing is that we were not utilizing it in a conference, but we were doing it one-to-one. For example, we were having Skype, we had WhatsApp chat, these video calls, or even we had FaceTime video calls on your Apple mobile phones. But once pandemic set in order to have a meeting or in order to have a discussion amongst a group of people, this technology was used. You must all be aware, and you must remember that pandemic was not an easy time. High Court, we had a lot of difficulty in the High Court, and I'm sure even in the districts you had a lot of difficulty. First, understanding how to go about and take cases through video conferencing. Make the lawyers understand, and the litigants understand that it will be seamless, there will be no difficulty, and that there will be no manipulation of their cases or data when they take it up through VC. Now, different courts across the country started using video conferencing as a means. We also did the same. Now, there was a video desktop which was already installed in our Ubuntu. If you remember video, right? Initially we used video desktop, the VC software, the video conferencing software, but it didn't work very well. It could only take about 4 to 5 people at a time, and once there were more participants, it just crashed. So what could be done? Now we have to move on. So the other initiative that the committee took was to get another video conferencing application called, I think it was Justice app. Sorry, it was, I do not remember right now, but I will let you know. Because what we are looking is, we are looking for a free software in an open source where you not pay a lot of money. Otherwise, there were applications like Zoom, even BlueJeans that we use it right now. These are all paid applications. But then we used a lot of open source technology and the open source VC. And in 2000, the rules for video conferencing for COTS 2020 came into being, and it was through a notification dated 12th of May 2020 that the rules for video conferencing group for COTS was promulgated. Now, I'm sure all of you have already gone through this. I will not take a lot of time in this. There are definition clauses in the first instance, and there are certain definitions that are quite important. One is what is the meaning of COT point? What is the meaning of remote point? What is a COT user or the remote point user? You know what we need to first understand is that in video conferencing there are 2 points. Well, for example, a point where I am right now is point A, and where my senior, Mrs. Casey Bafumpa, is there, let's say, for example, point B. And where Ms. Urvashi is there is point C. And these are different points that we are connected to. Now, for the VC rules, what is important to understand is that there will be one point where, let's say, for example, Madam Bafumpa is there, that is the COT point. Now, COT point is the COT room, or it could be one of the places in the COT which is physically convenient to make it a COT point for recording of the or for initiating the VC proceedings. Now, this is a COT point. Now, what is a remote point again? A remote point is, let's say, for example, me. I am here from another point where I need to communicate, or I need to have a conference, or I need to give an evidence or record my evidence from another point, which for the purpose of this rule is known as a remote point. And a person who is using the COT point will be called COT user, and the person using the remote point will be remote user. These are some definitions, I think, which is quite important that you should understand. And I do not want you all to be confused about this, but these are things, the definitions that we need to keep in mind when we use these rules. Now, if you see Rule 3, it gives you a general principle of how video conferencing works. Number 1 says that it can be used at any stage of judicial proceedings and proceedings conducted by court. That means it can be used right from the initial stage up to the end. It can be used in the appellate stage as well as the trial stage, at any stage of judicial proceedings. But there are certain protocols that we need to follow. Number 1 is that the decorum of the court, when we have a physical court hearing, what we all do is that we maintain a decorum in the court. The parties are supposed to come dressed up properly. They are supposed to not disrupt the court proceedings, and these are some of the decorum that we insist when we have a physical courts. Neither is the case when we record evidence or we have court through VC. All the laws that we apply in the court, the procedure under the CPC, CRPC, Contempt of Court, the Evidence Act, these are all, even the IT Act now, when we use VC, will be applied also while conducting video conferencing. And also it says that there will be no unauthorized recording of the proceedings by any person while the VC is in session. And another thing when we use VC is that the person in the remote point, for example, the remote point here is me. Now, as of now, you know me that I am KW Bhutia, and my identity is not in question. But there are times where you have a number of witnesses, 10 witnesses, 20 witnesses. You have never seen them. You just have the name. Now you need to ensure that the person in the remote point or the witness in the remote point is the same person, A or B, that is listed in your chart sheet. So for this, what is important is that certain documents, for example, identity card, election card, whatever it is, Aadhaar card, these are some of the identity proof recognized by the government of India, the state government, whatever it is. You need to show it to in the court point when you come there, or in the remote point to the coordinator that I am the same person, and I will be making or giving the deposition or the evidence. And in this matter, at times there are witnesses who do not have any document. In such cases, it can be recorded and the verification can be done later on so that the entire process is not disrupted. Now, what are the facilities that we require for a VC? Number one, the desktop computer that you may all be using, or a laptop computer, the speaker, a proper speaker, the microphone, speaker, camera, display unit, proper firewall for security reasons, adequate lighting. For example, right now, perhaps there is a lot of light at the back. You may not be able to see my face properly. These are also not proper settings, but as I said, quite in a secure place. Also, there is one equipment called a document visualizer. Perhaps on the last occasion also somebody may have questioned what is a document visualizer. It is an equipment, an electronic equipment, but there is a camera on one point which can actually show or can be moved anywhere. It can also pick up. It has an inbuilt microphone and can pick up your sound, where you can actually show your, like in the camera that I have right now, I can show this document, This is a document I can show you. And in the document visualizer, it is a similar equipment where once you put your document below and once the visualizer is on top, you can see the entire document. The pixel of this camera, it's very good and it's very, very clear. And these are some of the things that we require to facilitate video conferencing. Now, for the court point and the remote point, there should be some person manning these. In the court point, you all must have seen the honorable district judges of the districts have already appointed coordinators who are known as court coordinators. And in the remote point also, at times what you require is a remote point coordinator in order to enable a proper video conferencing or proper recording of the evidence from point A to point B, or from court point to the remote point. So these are things. And apart from that, apart from the courts, there are other institutions, for example, the observation home or the childcare institutions, forensic science laboratory, the medical unit, or the hospitals, where the remote point coordinator will be somebody as per the rules. For example, if it is the hospital, the medical superintendent. If it is the observation home, the in charge of the observation home, they are the
Sir, you have been muted.
Sorry, perhaps I may have muted myself. As I was saying that apart from the remote point coordinator and the court point coordinator, there are other coordinators such as the juvenile home observation coordinator, the forensic science laboratory, the in charge there, administrative officer, who will be the coordinator as per the rule. Now, there are certain things which a coordinator requires to do that inform all the persons, the concerned persons, that to be present in the remote point or the court point on time, at least 30 minutes before the scheduled time, so that we can have a proper briefing for people who have never used VC, so that there is no disruption during, to inform them that there will be no unauthorized recording of the device. For example, if some people have their mobile phones or any other devices, you can, during the course of the proceedings, you can ask them to keep it for the coordinators, and at the end, the coordinator may return it so that there is no unauthorized recording. But does that mean that there will be no other persons who can witness the proceedings? The answer would be no, according to the rules. According to the rules, the idea is to just give a digital platform of the court proceedings. The court is an open court where any individual can actually come and witness the proceedings. Now, even when there is a VC, the video link can be accessed, can be shared with anybody. Anybody can come and listen to the arguments. But the only rider would be where the court feels that this is a case where the persons unconnected to the cases should not be called, should not be present, such as while recording the evidence in a POCSO matter. In such cases, only the concerned persons, the concerned advocate, and the court staff will be present, like we record the statement in camera. These are certain things that we require to keep in mind under the VC. Now, the most important thing that I have noticed in this rule is how do we initiate video conferencing? Not technically, but procedurally. How do we initiate? Now, Rule 6, if you see it properly, it says that any party to the proceedings, could be the advocate or litigant, should desire that the evidence should be recorded or the argument should be heard for video conferencing, the concerned party will file an application before the court. Will move a proposal. Once the proposal is there with the court, one thing the court should ensure is that before you receive that proposal, you ensure that the other party has been informed of the idea that one of the party would require or would like to have the proceedings conducted through VC. Except there could be an exception if there is an urgent hearing. It may not be proper, or they may not have sufficient time to inform the opposite parties. And once you receive the application or the request, the court will ascertain and will pass the order, and will also fix a time, date for recording of the evidence, or for hearing in the matter, or for hearing the argument, appeal, whatever it is. A particular time will be fixed, and a particular the schedule will be made. So this is one thing. And the court will also ensure through their coordinators, in the coordinators here in the districts would be the technical manpower that has been appointed. Their job would be that the advocate concerned, the parties concerned, will be supplied with through their email ID, official, whatever email ID they have given to you, or the mobile phone, the video conferencing your ID, or the video conferencing email ID, or the ID, whatever you call it, will be provided to them right before time. And if there are any documents that any of the parties required to examine or would intend to examine to the witnesses, all these also certified by the court will be sent to the opposite party through their email ID or to their mobile phones on time, so that when there is a recording of the statement or argument, the VC, the video conferencing, goes seamlessly. Now there will be service of summons. For summons also, what has been provided in the rule is that along with the summons, if there are any documents that a party requires, a certified copy or which is photocopied will also be sent along with the summons, with the time and a schedule fixed for VC. Now, these are certain things which I thought was important.
If I may add to what you had said about the parties applying for, I just wanted to mention that the rules provide a schedule which gives a form which the parties are required to fill, and if it is filled, then the court can fill in the details and then fix the VC accordingly. So the parties
Absolutely
can
right.
fill up the form.
Absolutely
and
right.
the court.
Yes, absolutely right. I think on the schedule 2, there is a schedule, there is a form, and that will be the form which will be used by any of the party intending to have their cases heard through video conferencing. Thank you, madam. That is absolutely right. Now, as I said about exhibiting documents, it will be exhibited. Now, exhibiting document will be, I think, sometime while recording of the evidence, if you don't prepare beforehand, you'll be quite confused as to how would you be able to exhibit the documents right on time. Now, for exhibiting document, as I said, a person who intends to exhibit document A, B, C, whatever it is, if it is with the court or if there is any new document, if once the court allows, if they intend to do it, the witness will be sent along with the summons a photocopy of these documents. Now, in a remote point, if there is any witness who has not received it, what the court can do is one copy of this will be scanned and be sent to the email ID of the remote point coordinator, who will in turn print it out and show it to the witness concerned. And these documents can be marked like any other documents. And once the depositions are recorded, once the statement is recorded, now how do we obtain the signatures of the persons concerned? Now, under the rule, what has been provided is that once the statement is recorded, everything is in order. Once, if the persons concerned are in the court, some of the persons, the witnesses and the remote point, the court will certify and it will send it across to the remote point in the official email ID, who will print it out, obtain their signature. The remote point coordinator will also endorse his signature to authenticate that it was done in his presence, and this will be again sent by email to the court. And in a working day, in let's say 3 to 4 days thereafter, within these many days, or as soon as possible, the hard copy or the original copy with the signature of the witness and the coordinator will be sent to the court by a registered post or courier. And also, at times, there are witnesses who have digital signatures, there are courts who have digital signatures. So if there are these digital signatures, it can also be authenticated by digital signatures, which will also be equally valid. Now, what about judicial demands? It also provides that, and we have been doing, I think, in almost all the districts, the remand, not from the first remand, as I've said, I think earlier as well. Please do not take first remand through VC. Even in the rules provide that in exceptional circumstances you can, but I mean, as an experience, I think I may request you all that your first remand, police remand or a GC remand, should be by physical means. You see the accused, you talk to the accused, and then give the first remand. The subsequent remand, the subsequent judicial remand can be given to the VC, and that will save a lot of time. The rule also provides that in exceptional circumstances, 164 can be recorded, charges can be framed, and even 313 can be conducted to VC. That is in exceptional circumstances. If you see it, it is under Rule 11 of the rules.
Ajay, just to share one regarding remand, VC remands. Just to share one such situation that arose yesterday, because
Yes, ma'am.
both the Learned CGM and GEM, Learned CGM was on training, GEM Gangtok is on leave. So the GEM Mangan was placed in charge. Now they had a remand, but due to the presidential visit, most of the police people were deployed, so they had manpower problems. So the police could not take the 3 accused persons to North Sikkim. So due to this, then the SP called me. So considering this was a special situation, the remand was done through VC, but I made sure that all the 3 accused persons were personally produced before me, so that I could see them physically, check their names, details, and thereafter the magistrate who was placed in charge did the remand through VC also. All right, so this is just to expedite the matter and to meet the exigencies of the situation. So sometimes situations like this can arise, and I think we can adopt these means, but we have to make sure that the accused persons are physically
Produce
examined by at least one officer.
Present. Correct. I think, Madam, that is absolutely correct procedure which Madam has adopted, and Madam is speaking out of experience, because many of us, we don't have the experience that Madam has. Madam has been a magistrate for a very long time, and also now the principal district judge. And what is important is that how do we meet up these kind of situations? There are circumstances like this. Madam knows, I know, that at time there were just 2 magistrates across the entire state. We didn't know how to manage or how to take remand and what to do when one of the magistrates was on training outside the state or absent, or even the other magistrate was absent. And these are the situations, I think, through experience, Madam has said. And Rule 11 also provides that in exceptional circumstances, remand can be done through VC. And Madam has done it rightly, and with a rider. As I was also saying that please take your first remand. The rule provides you. But Madam has taken this exception because Madam knows that if you do not have it present physically, there could be something wrong. And if something goes wrong, it is the concerned judicial officer who will have to give the explanation. And though it was not Madam's role, Madam has seen physically that these persons were all right and permitted the police remand through the VC. Madam, I think that is absolutely correct, that there is no infirmity in this procedure. Anybody else would like to share any of their experience?
Excuse me, sir. Am I
Yes.
audible?
Yes, of course, ma'am.
Sir, I wanted to get clarification with remote point coordinator, because sir, I have this case where I had to conduct the trial via VC, and the witness was appearing via VC from Maharashtra, and then he was the prime witness, so I had to conduct it through VC. Was unable to come, but the problem arose when after the deposition was recorded, I sent it via email, and the remote point coordinator there in Maharashtra refused to authenticate it, sir. We said that we do not have, our provision does not say that we are supposed to sign on it, so we are not going to sign. That's what we said.
Madam, I'm sorry, your voice was not very audible. Can others hear her properly? Or whoever do not have proper connection, we could send a message in the chat box as well. I can read it. Just Urvashi, could you please tell once more? We couldn't hear it properly.
Sir, am I audible now? Hello?
Not clear.
I think you need to increase your volume, Urvashi.
Yes, sir. Hello? Am I audible now?
Yes, to some extent, please.
So, with regard to this remote point coordinator, I had recorded the evidence of the witness who was appearing via VC from Maharashtra, and then after the deposition was recorded, my coordinator here signed it, I signed it, and then emailed it to the court in Maharashtra where the witness could affix his signature. After he affixed his signature there, the remote point coordinator, as mentioned, had to sign the deposition, had to sign on it, but he refused to do so, saying that their VC rule does not direct them or give any direction with regard to having affixed their signature on the deposition. So he refused to sign on it, sir.
Is it the remote point coordinator who refused to sign on it?
Yes.
Of Maharashtra court?
Yes.
Well, but I think these are certain procedural aspects which will occur during whenever we have this kind of recording. Now, in these matters, what you can do is you can send an email or write it directly to the concerned court. Let's say the concerned district court. You can write to the district judge, mark a copy to the Registrar General of the High Court and the CPC of the High Court. What we can do is we can follow it up. All right? Because the VC rules is not only applicable here, it is applicable throughout the country. Right, ma'am? And yes, if there are other problems from other districts also, you could write to us, you could inform us on time so that we could take it up with our counterpart in the other states. All right, Mr. Roshi? But I think just because of the signature of certain remote point coordinator not being there will not invalidate your deposition. All right, you may go ahead, but at least once you can always get back to us. Now the other provision that we have it in the VC rule is the cost of the proceedings of the costs of the VC. Now, at certain times we require a lot of expenditure. The printing is to be done. There are other expenditure involved. Whenever there are expenditure involved, the court may decide. In civil cases, it is generally the party who will apply for VC who has to bear all the expenses. But in criminal cases, it could be the party who will actually apply. But PD expenditure, and it is also proper for a court to say that there will be no cost. If there is hardly any cost, and none of the party to bear cost, I think that is also absolutely okay. And apart from this, the court proceedings, what we have is we have our legal aid clinics, we have our local adalat, which on the 12th there is another local adalat coming. Now, in these type of matters also, you can have your discussions through video conferencing, and I'm sure that many of you have already done this. And if you pass any order or an award in a local adalat through VC, that will be equally authentic and it will be acceptable. Rule 15 provides that it will be proper. And what is the platform that you are supposed to use for VC? The question comes up is the platform that the High Court has actually provided from time to time will be the platform that you can use, not any other platform, generally. For example, right now we have our Jitsi Meet, which is an open source platform. And Meet has also been given the go-ahead, which the High Court is using it, and also the Academy. But Meet is a paid VC app or a VC application. And apart from this, at times when it is very difficult, the court can also determine that when there is certain failure of one particular platform, it can use another platform which may not be the platform approved by the High Court in order to take care of that particular eventuality or that particular circumstance. And also, times if there is any difficulty if there is difficulty in implementation of these rules, there is also a provision where the High Court has power to relax one of these rules so that for the purpose of there is equity. All right. So I have come to the end of the VC rules 2020 as well, and I will now move on to another topic of the digitization. High Court of Sikkim, digitization of record rules, which is of 2016, right? Now, all right, before doing this, I think you must have all seen that there are a lot of notifications which the High Court took it out later on, where the platforms were provided. There were helpline numbers also provided for proper implementation of the VC rules. For the High Court, we had a particular number, which this morning when I tried was functional still. It was a toll-free number, 14646 or something, which was being used even right now. So these are certain information apart from the regular notification that I wish to from the learned members participating in this program. The other rule that we will discuss, which is a very short rule, it just has 6 rules there. This is the High Court of Sikkim digitization of records rules of 2016. As I've said, there are just 6 or a very short rules, but I will add here that though it is short, it is very, very important. Now, what do you mean by digitization? Digitization in a common parlance, what you can understand, it is converting all this analog data or information from the hard copy or from analog to digital form or digital data in an uneditable format. It could include files, documents, images, voice, videos, electronic means, which a computer can understand. This is the meaning of digitization. And it will have the same meaning that the IT Act of 2000 provides. Now, under the rules of 2016, in the High Court, the person concerned who will man the digitization will be the Registrar General or the other officers which the Honorable Chief Justice designates. It could be the judicial law, it could be the Deputy Registrar Judicial, or any other officer who will see that the implementation of the digitization rules is properly done. And in the district court, it is the administrative officer or any other officer which the concerned district judge designates will be the person who will be responsible for proper implementation of the rules. Now, as we all know that this digitization process began in Sikkim somewhere in 2016-17, first from the High Court and then to the District Court. Initially what we did is, since there was a large data to be digitized, a private company was engaged by the name of IPL from Bangalore. They had their own manpower. They scanned all the documents, the old documents of the High Court, the old documents of the district courts, and then once their term was over, they left. And once they left, what happened is that in order to continue, in order to sustain, from the High Court, we not appointed, but we designated some officers that they will be responsible for ongoing planning and digitization work. Similarly, in the district courts, the district judges also, they designated some officers, the court system officers, system administrators, to ensure that the current files or the running files are also digitized so that it could be saved in the repository. Now here, in the High Court and also in the districts, the older records, you have your own repository, you have your own, here, what we have done is we have saved it in our server. It can be accessed anytime. You have your own portal. You can generate your access, your password, and then gain access for preservation. Now, the rules provide that how do we preserve and how do we eliminate the records? It says that in civil cases, after digitization, the judicial records, apart from the ones which I will tell you, can be destroyed, can be eliminated. But these are the documents which cannot be destroyed and which has to be preserved for a period of 30 years. The judgments could be the High Court, any of the district courts, civil judges court, any court. Certified decree, certified or signed decree, the unwritten or original title deeds which the parties must have forgotten to take it back. You'll have to preserve it for 30 years. The verification or formation of the parties, the order sheets, the Wakalatnama, the entire case records, the pleadings. In short, let's say the entire records of your civil cases have to be preserved for 30 years. And so also in criminal cases, many of these Wakalatnama, the judgments, the unreturned original documents, the signed order sheets, the depositions, these are all to be kept for 30 years. And this rule also provides that not only the judicial records, but also the administrative files and the account-related files are to be digitized. And once digitized, it can also be, some of the important documents can be kept and the others can be eliminated. But I would say that it would be, I think, wiser, since we do not have so many caseloads to preserve the case files, because you never know at one point of time or the other, it could always be revived and they would always ask you to retrieve these old records and give it to the High Courts. Though the digitization rules clearly provides that these unnecessary documents can be disposed of. But what you can dispose of is not the original documents, but let's say photocopies, the second copies. Even in the district court you have, but here in the High Court, the practice is that along with one memorandum of appeal, there are 2 or 3 more copies or 4 copies filed together. So you have one original, 4 copies. What we can do is we keep one, destroy the other 3, because we don't need, it is only occupying the space, but it has to be disposed of as per the rules in the presence of the Registrar General or the officers concerned in the High Court, and also in the districts. If it has to be disposed of, if it has to be eliminated, it has to be done in the presence of one of the officers designated by the concerned district judge, and there has to be a certificate that it has been done in a proper manner. Like I said, this digitization rule is a very short rule, and there was nothing much to discuss on this, and I think I have come to the end of my presentation. If there is any question on this, I will take it. But before that, do you all know, I'm sure you all know this and you have seen also, once we register our case online, it has been going on for a long time, there is CNR, right? The number generated. It's a unique case identity number, which is known as CNR, or case number record. A 16-digit word. You've seen, right? You've all noticed. Will you know the meaning of this 16-digit? If you do not, I may like to just inform the learned participants. There are 16-digit code, which is known as CNR or case number record. This is unique. With this number, you can search your case throughout the country. Now, one CNR is not replicated in any courts, in any states, or in any high courts. This is unique to only a particular number. Now, from the 16 one, let's take an example. It is something like this. 2022 at the end, I'm coming from left to right, okay? 2022 at the end, hyphen, let's say 015295, any number, but there are 1, 2, 3, 4, 5, 6 digits, hyphen, let's say 01, G, and let's say SK, all right? Or let's say GK. Now, what does this signify is that the first two digits SK signifies the state. Second two digit, if it is GK, or let's say Namchi NM or Gyaltsing GL or something like that, that will be the district, or let's say Gangtok district. All right. 01 thereafter will be the establishment code. For the district and sessions court, it was always 01. 02 will be for others. Let's say, for example, 04 is for civil judges. All right. Then thereafter, the other 6 digit is the case filing number. This is, let's say, for when I said here 014825, whatever it is, 6 digit. This is the case number getting generated. Then it will be the year of filing. Like I said, the 2022. So this is a unique number, 16 digit, which is applied across the country, known as CNR, by which you can identify your cases. Not only you, the litigants, the advocates, and this is, I think, important. Even in Justice app, it is important that if you want to find any particular case, you can enter this CNR, or right now it has been made more easy by the QR code. You just scan the QR code and then you have it. You have all the details of that particular cases. Now, the initiative of the e-committee, by providing you all these, is to make your work much easier, so that you don't waste much time in all these. Even in your CIS right now, 3.2, there are already pre-prepared formats of your summons, execution, whatever it is. You don't need to type your entire summons. If you do it properly, the name or that name for that particular charge sheet, from the charge sheet, the name of the witness, the parentage, addresses, everything can be pulled from that particular portal, and in your CIS 3.2 itself, when you generate summons, it has a template, and all these details will be printed. A person will not sit there and write the name, look at the physical charge sheet, and because it takes a lot of time, especially in the East. There is one person dedicated for typing the summons. It takes about 2 to 3 hours to type the summons in a day. So if you can utilize all these functions, I think it will be much, much easier, so that we don't waste our time doing this, and our productive time could be utilized in taking up cases. I think I've come to the end of my presentation. Thank you. If there is any questions, I'd like to take. Otherwise, the director can ask me questions now.
Yes, any no question, I think.
No questions, sir? So, thank you, sir. Thank you so much for giving me an opportunity to share my views with everyone. Thank you.
Thank you, sir. Thank you. Now we have come to the end of today's program. It is my honor and privilege to conclude the same by offering vote of thanks to all, especially the learned resource person, who, keeping aside of all administrative works of important natures on today's board, has been kind enough to share the precious time with all of us and deliberate on all 3 topics of today's sessions in very simple and lucid manner, easy to understand to each and everyone, for which I, on behalf of Sikkim Judicial Academy, would like to offer sincere thanks to him for his wonderful and remarkable contribution made to all of us here. I equally would like to offer sincere thanks to all learned judicial officers for participating and sharing the precious time with all of us with the esteemed presence in today's session. Thank you all. Lastly, I would like to offer my sincere thanks to the all technical team of Subordinate Courts and Sikkim Judicial Academy for helping us by sharing their technical knowledge extensively and making the today's session a great success. Thank you all. With the permission of learned resource person, I would like to declare the end of today's session. Thank you. Have a nice day. Thank you so much.